Now that we delve deep into the topic of civil rights and civil liberties, I would like to open this video by explaining the difference between civil rights and civil liberties as ideas. Civil liberties is about negative liberties. It's about all those things that government may not do. For example, freedom of speech means government cannot limit your speech. For example, we talk about rights. You talk about rights that are positive liberties. That is to say, the government has to take proactive steps to do something to guarantee that you have those rights. For example, the right to vote. Unlike with freedoms, it's not enough for the government to get out of the way and not physically restrain you from voting. The government has to be able to guarantee that there are voting places, that there is safe and secure access to them, etc. So if civil liberties are about the things that the government may not do, then civil rights are about things that the government must do, must guarantee. For practical purposes, the distinction between the two can be blurred, and things get a little bit more messy when we think about civil liberties that are in common parlance called rights. For example, we always say property rights. We do not say property liberties, even though in the technical sense, the property rights that are guaranteed in the Constitution are property liberties. For example, Amendment 5, the takings clause. The government cannot take your property without just compensation. That's a liberty. That's something negative. Government may not take your property without just compensation. So this difference between rights and liberties for practical purposes turns out to be more semantic than real. But let's begin this topic of civil liberties with the First Amendment, and specifically with freedom of speech. So the government cannot abridge freedom of speech. The next thing that I would like to point out is, even though the liberties are and rights are very real, government can impose some limitations on them. The question is, how many limitations? That's always been the question. How many limitations government can impose on civil rights and civil liberties? When it comes to freedom of speech in particular, there are some types of speech that have never been protected. In other words, they have never enjoyed even a small degree of protection. Obscenity is one. For many decades, the court has struggled to define obscenity, but in 1973, in the case of Miller versus California, it came up with a three-part test, and a particular work in question has to meet all three parts in order to be qualified as obscene. And even though the court came up with this relatively clear definition of obscenity, its clarity is more on paper than in reality. And the reason why is because in reality, it's very difficult to meet the last part of the obscenity test. And the last part says whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. If a state obscenity law is thus limited, First Amendment values are adequately protected by ultimate independent appellate review of constitutional claims when necessary. So if the work has no literary, artistic, political, or scientific value, then it will not be protected if it also meets the other two definitions of obscenity. But if it has some literary, artistic, political, or scientific value, it will be protected by the First Amendment, even if it does meet the first two definitions of obscenity. So you can always argue that any work has at least some artistic or literary or political or scientific value. For this reason, almost nothing is obscene. So for practical purposes, the definition of obscenity does not work if you talk about limiting works based on obscenity. Almost nothing is obscene. There are other types of unprotected speech, for example, fighting words. Fighting words are those words that would induce a reasonable person in whose presence they're uttered to a physical confrontation. There is not a definitive list of what is or is not a fighting word. In different eras, different words were considered fighting words. For example, in the 1940s, some people were arrested for calling police officers fascist because the United States was at war with fascist countries of Germany and Italy, and the word fascist had a different connotation than it does today. Uh, Racial slurs generally are considered fighting words. But once again, remember, in order for this type of speech not to have protection, to be considered fighting words, the words must likely to result in a physical confrontation. So if these words are posted on the internet, they're not fighting words because they're not likely to result in a fight, because no one has yet figured out how to punch or kick someone through the computer screen. But if they're uttered in the physical presence of a particular person who can be incited to physical confrontation as a result, then they are fighting words. Defamation is the next category of unprotected speech, and it comes in two varieties: slander, which is verbal defamation, and libel, which is written defamation. Also, anything that's on tape, on disk, anything that's video recorded on the internet in the cloud, that's considered libel. So slander is only verbal. In the United States, the standard for defamation is not easy to meet. First of all, a statement uttered must be a statement that is about facts and is false. So if a statement is clearly a statement of opinion, that's not about facts. You can have any opinion that you want. For example, if you think that the particular car that you bought is a really bad car, you can say it. Or you can say it's an ugly car, it's a bad car, it's a matter of opinion. But if you say that the salesman specifically took out the back seat from the car and put an explosive device under the front passenger seat and sprayed the glove compartment with poison, those are not opinions. Those would be statements about facts. Now, they could be true or false. And if they are false, then you're potentially opening yourself up to a defamation lawsuit. So when you talk about statements that can be checked vis-a-vis factual information, that enters the domain potentially of defamation if the statements are false. For politicians, celebrities, and public figures of all sorts, it's not enough even to have statements of facts that are false. They would also have to prove that people who made those statements or statement made them with actual malice. Actual malice means that they knowingly made false statements, or they made them with reckless disregard for truth. That is to say, even if they didn't know the real truth, they could have easily checked it. So they have made clearly false statements with either knowingly or with reckless disregard for truth. Then they can be sued for defamation. Also, I should note that satire is automatically out of defamation domain because it's not meant to be taken literally. So it's not a statement of facts, which is why comedy shows like SNL can get away with saying all kinds of stuff, making all kinds of fun of politicians, because they're not making literal statements about facts. Child pornography has never been protected speech. Jared Fogle went to prison, as you know, the former Subway spokesman who lost a lot of weight, eating low-calorie Subway sandwiches. No, child porn is not protected. Perjury is not protected. Perjury is lying in court. You cannot go to court and then under oath say, well, no, I didn't really witness this event, and then it turns out that you're on videotape witnessing that event. You cannot tell to the judge as an excuse, hey, that's my freedom of speech, I can say what I want. No, you cannot perjure yourself. You cannot lie under oath. Blackmail is when you try to obtain something, money or favors, usually money, as a result of a implied threat or explicit threat to reveal compromising information. So blackmail is also not protected by the First Amendment. True threats is when you try to really threaten someone, to threaten someone's life or health as opposed to wishes. For example, if you wish someone ill, if you wish that someone dies or someone comes to harm, that's actually protected by the First Amendment. But if you really threaten them, then it's not protected by the First Amendment. Well, what's the difference? The difference really is the context. It's the context that decides which statements are statements of wish and which statements are just literally statements of threats. Solicitation to commit crimes, you cannot ask someone to commit an illegal act for you and then use freedom of speech as a defense. So if you ask someone to commit a crime, then that act of asking is also a crime. Heckler's veto. Heckler's veto is interesting because not many people understand it, especially when they hear it for the first time. Heckler's veto is when police can stop you from speaking, even though the content of your speech is perfectly protected by the First Amendment, but they do so because the audience begins to heckle or otherwise show significant displeasure, and the situation could escalate. So if a situation could escalate into violence, clearly protection of life and health of the people takes precedence over speech. So if there's a threat of escalation, they can police can usher you off stage and say, okay, you're done talking, and then you cannot sue them for infringing your First Amendment rights if the situation warrants the protection of life or lives due to hecklers, due to the angry audience. Incitement to imminent lawless action is very important because this is the current generic standard of speech that we have. Incitement to imminent lawless action is a standard that the court posited only in the 1960s as these standards for differentiating all kinds of speech in terms of protection and lack of protection under the First Amendment. So the speech, in order not to have First Amendment protection, must first call for an illegal action, and the action must be imminent in its nature. That's the first, and the second, this unlawful action called for by the speech must be about to happen, must be imminent. So if someone were to say, I'm the leader of this biker gang, and I see other bikers of a rival gang over there, let's get our chains and our knives and let's go and beat them up and cut them up. That would be, based on the content, probably incitement to imminent lawless action. If, on the other hand, someone were to say, well, you know what, it would be good to overthrow the government sometime, maybe who knows when, maybe next century, maybe a century after that, but the government is kind of not good and deserves of being overthrown. This sort of speech most likely would be protected under this current standard, because while it calls for an action that is illegal, it is not imminent, and also it is not likely to happen. Just because someone says something, in this case, to call for an overthrow of government at some unspecified time, this would probably be protected. But again, everything depends on the context. Finally, commercial speech. Commercial speech has limited protection since the 20th century. Prior to that, commercial speech really didn't have the First Amendment protection, but currently it does have some limited protection.